cause number AP 77105, Tyrone Jamal Williams versus the State of Texas.
Chief Judge, Counsel, and may it please the Court. My name is Clay Thomas. I represent Tyrone Jamal Williams in this matter. This is a capital murder case out of Hunt County in which Mr. Williams was convicted of murdering his wife and mother-in-law. He was subsequently sentenced to death, and it's for that reason we're here today. To start, I'd like to take you back just a bit in the fact that a few months back I was in the middle of a hearing on a capital case, and some newspaper reporter asked me, well, surely you believe in the death penalty, don't believe in the death penalty. And I said, well, no, you're wrong. Actually, I do believe in it. I just think you've got to get there the right way. And largely that's what we are here for today. We have roughly three issues here. One of them, of course, is the prohibition of jurors with complaints against the death penalty of being kept silent. I think it is a well-worn path, but probably not well-worn this way. It seems to me that a juror is nothing more than a voter, and a voter is going to have some opinion in the community standards to which that community ought to apply the law. Now, granted, one can certainly say that, and I think this is the way the law basically holds it, is that we want you to apply the law, but we want to apply the law in the way that we say, not in the way that you believe.
Okay.
Well, for instance, if you look at that, Texas is a representative republic. It is not a democracy. Okay, and so when was the last time the death penalty was actually brought for a popular vote? I don't know. I do know that the legislature brought it back at the end of 1972. But certainly in 52 years, community standards must have changed. Now, if what we tell individuals that are sitting for a jury is that we respect your religion, but that doesn't work, and you have an issue with which you disagree with the death penalty, why is it that you should be allowed to serve? Well, again, the right to serve on a jury is much akin to the right to vote, because that jury does make votes. And it seems to me that when we look at that from that perspective, we have to take into concern those community standards. Now,
Do you have some specific complaints about some specific jurors and how they were dealt with?
I do. In this case, for instance, we have Ms. Burton who said, well, if something personally happened to someone in my family, like my child, for instance, I may feel like I would want it to happen. But at the Batson hearing, the state said she did say she strongly supports or would support life without parole. That's not abhorrent. Mr. Henry, I oppose the death penalty. I do not believe the state should be in the business of ending an individual's life. I didn't believe my personal bias would impact me from being able to serve on the jury. But Mr. Little said that the philosophical opposition was enough. Mr. Singleton also said he felt this was God's providence to take a life. Now, the larger votes are, of course, or the larger issues have been in the past has been the issue of religion. But the fact of the matter is that this hasn't even been put before a popular vote in at least 52 years. And it seems to me that when we're concerned about community standards, that should say something, okay? Our community standards have a tendency, I believe, to evolve over a period of time. And it should be the jury that gets to decide those, not the legislature and not the court.
Are you advancing the argument that the courts should allow people who have an objection to the death penalty in general to serve on a death case, on a case in which the law permits the imposition of the death penalty?
I am, and here's why. When we think of the reason to take someone's life, the reason should be so great and so egregious that what ought to happen here is that even that person that says, I just don't feel good about doing it, would do it anyway. Because it's soul shaking. As opposed to just saying, we've got an issue here where the law says if you have an objection, you can't serve.
Do you have any objection to the rule that would say that before a person is qualified to serve on a jury, that they be somebody who is capable of following the law that will be given to them by the court?
I do not. I have an objection to the fact that they get asked about it. Okay? And please understand, death penalty cases are extraordinary matters. They are not like everything else. For instance, if I were to step back and say, okay, you've got a sentence from 2 to 20, okay? If you have a sentence from 2 to 20, then what you wind up having is an issue where you would have to ask the juror, okay, can you go with 20? Can you go with probation? We've all been through this. We know this, okay? But death is different. Death is the finality. There is no hope past that. There is no life past that. And that's where I've got an issue with it. It ought to be that when someone gets their lives snuffed out, whether it is by lethal injection or, as we're hearing lately, firing squads, electrocution, doesn't really matter. The reality here is that what ought to occur is that there is a visceral feeling. Now, I'm not saying that the jury couldn't get to this point. In many cases, they can, even if they have an absolute thing of, my God, I just going in, I can't do it. But that is what trials are about.
So you're saying that because death is different, people should not have to follow the law in death cases? That's what I think I'm hearing you say. But in other cases, non-death cases, people should, hopefully, you would believe jurors still have to follow the law? I mean, I'm having a hard time following.
I understand.
You're asking us to say jurors don't have to follow the law.
Is that right?
Am I right about that?
Well, the way you're thinking is correct. However, maybe not so correct. And the way in which I would say it's not correct is that there is I just think the law is wrong. Let's face it. I mean, the reality here is that you're saying we've got a certain attitude or a certain place we want to get, okay? When we talk about justice, we talk about an unbiased justice, correct? Both sides are on even keel, correct?
Including unbiased not biased against the law, right? Against the actual law that the legislature passed.
Right. So what I'm saying is if you hold that bias against a juror or a potential juror, do you not also hold that same bias against the defense? I mean, you can't go one or the other. The reality here is that this is not something that really ought to be a matter of a subject.
Well, counsel, following on what Judge Erie said, I mean, you're certainly aware that there are groups in this country that want to completely end prisons, and so would we hold it to that? Would we hold those potential jurors to the same standard? Like, it's a burglary case, and they say, well, I just don't even believe in prison, and the defendant's not probation eligible. I mean, surely you wouldn't say that we have to put those people on a jury, would you? Or would you? I guess I shouldn't put words in your mouth.
I think death is a special case. I do. And yes, there's certainly very, for instance, Florida, now you need 4 for the death penalty. Georgia, no, I'm sorry, Alabama, I believe you need 2, 10 rather. So, and actually I meant 8 for Florida. So in Florida and Georgia, they've actually made it even less. So they've actually changed the playing field. At least here, we're somewhat unanimous. But that does not get us past the point of saying, is it proper to have a law which actually states that you must be willing to give that ultimate sanction, even if you don't agree. And if you don't agree, by the way, you can't participate.
Am I correct that you are posing this as a right of the jurors to serve?
Yes, Your Honor.
Counsel, since this was mentioned, I would like to go back to something you said. You said that we do have, as citizens, a right to serve on the jury.
That is correct.
Where does that right come from? I have not read that anywhere, as far as
Well,
I know.
I would see that's an extension of the First Amendment.
Is it not analogous to the Batson holding?
I'm sorry?
Isn't your argument analogous to the holding in Batson, that the jurors have a right to serve?
That's correct.
Okay.
And I see my time is almost up.
Did you reserve time for?
I did.
Okay, thank you, counsel.
Good morning, Presiding Judge Keller and members of the Court of Criminal Appeals. My name is Steve Lilly, and I represent Hunt County in this case. The first issue, which was the issue that was brought up by the appellant here just now, is, I think, more accurately stated, is whether the state unconstitutionally challenged for cause and used peremptory strikes against potential jurors who have personal scruples of varying degree against the death penalty. 3 of the 4 jurors that were excluded from service were, the state used peremptory strikes against. One of them was a challenge for cause. And it's important to note, first of all, that their opinions against the death penalty was a primary reason stated by the state, in fact myself, as the reason why we were using a peremptory strike against them. And that was not something...
Was there a challenge made on those 3 for cause, and was that denied, and then you had to use your peremptories?
For one of them, from my memory and based on my review before today, one of them we did attempt to use a challenge for cause, and that was denied. And then we used a peremptory strike. That was juror number 17, but my memory serves. Juror number 113, we used a challenge for cause. It was granted. The other 2 were peremptory strikes initially, because the state did say, I don't believe that this juror has said something that will rise to the level of a challenge for cause. We nevertheless find them to be unacceptable to the state. So the point of that is, though, is that there was no objection at the trial court level on this ground. And so I think the more fundamental issue, or one fundamental issue, is whether or not this error was even preserved for appeal. There were objections based on Batson on 2 of them, but the other ones there was not. So there was no objection at the trial court level based on the ground that the appellant brings forward today. And it is important to note that Presiding Judge Keller, you mentioned the Batson issue as being, or this being analogous to Batson. It is, but it isn't. Of course, Batson deals with the right to be free from racial and gender discrimination in the jury selection process, having the ability to serve on a jury. But there is no, to the point that was made earlier by Judge Walker, there is no fundamental right for service on a particular jury, and that is different from the right to vote. Now, the appellant tries to conflate the two in his brief and in his argument, but the two are very different. The right to vote is a fundamental right recognized by the Supreme Court and other courts, but the right to serve on a particular jury is not, and that just makes sense.
Can I get back here? You mentioned
Yes.
something about the objection being made. So was there no objection made at the time of jury selection that this person is being excluded based on some First Amendment right to serve on the jury, or was it just based on race or gender?
For the two Batson challenges, it was based on race, and I believe one of them was female, so you can see that as being both. But no, not on this ground.
So the state wasn't put on any kind of notice that the defense objected to jurors being excluded because of their belief or non-belief in the death penalty?
No, Your Honor, they were not. And I believe there may have been, I don't want to misstate the fact there may have been some global motion filed before jury selection started, but as far as these particular, I don't recall that, but I don't want to say affirmatively that there was not. But as far as these particular jurors, no, there was not. I do know that that opposing counsel, the appellant, did identify three potential issues that they wanted to argue before the court, and I'm assuming that one or two of those will be talked about in his rebuttal time. So I don't want to, I do want to address those with the idea that they might be addressed later. And I think maybe it would be best to start or to move to the fourth issue, and that is whether or not the trial court committed error in refusing to admit 79 pages of deposition testimony that was admitted as testimony of a witness who wasn't available to be there during the punishment phase of the proceedings. This was the appellant's grandmother who the parties went down to Beaumont to talk with and do a deposition of. And when we came time for trial, the appellant attempted to admit the entire deposition testimony for the jury to consider, but the state objected to about half of it. And the court reviewed it and determined that about half of it, 79 pages or so, was irrelevant to the issues pertaining to punishment in this proceeding. And therefore, the trial court decided it was not going to be permitted, it wasn't going to be admitted. Now, that was obviously I don't want to say obviously, but it was something that was preserved for appeal, and I did want to address it, and that is that there are two standards by which we can look at whether or not, or what type of evidence is admissible in the punishment proceeding in a death penalty case. So this state talks, the Code of Criminal Procedure, Article 37071A1, it talks about the evidence of defendant's background or character is the limit, I guess, is specifically by statute relevant in the punishment proceeding in a death penalty case. Now that is a broad, and it should be, that is a broad category of evidence, but it's not unlimited. It talks about, the statute specifically says, the defendant's background or character. And what these first 79 pages dealt with were the defendant's grandmother's family history, and it was a compelling and a very sad history, but it was not the defendant's.
Did the defendant live with the grandmother or view this abuse or anything like that?
No, not the grandmother. No, not in any extent that I'm aware of. Judge, thank you for asking. I think that there may have been a time where he did live with his grandmother later on and then lived with his mother. I don't recall that specifically, but the point of, and that was likely covered in the last 77 pages that was admitted, because it wasn't the entire testimony that was thrown out. I don't want to say thrown out, but not admitted. It was the first part, which dealt specifically with the grandmother's raising, the grandmother's tragic upbringing, that all dealt with stuff before he was born. And so we the trial court correctly parsed that out and saying that these first 79 pages plus deal with tragic circumstances that don't have anything to do with the defendant. He wasn't even born yet. In fact, his mother is only mentioned one time in the first 79 pages of that trial, that deposition. But after she comes into the picture, the trial court decided that was relevant, and the court was allowed to consider it. And so we believe this was a proper ruling under Article 37071, and this court has said that the testimony has to have a more than tenuous connection to the defendant's moral culpability, and it just strains strains credulity to say that the grandmother's upbringing before he was born has anything to do with the defendant's upbringing or the defendant's moral culpability. And he was not born, he was not aware of this, maybe he was told later, but it doesn't have anything to do with him. And so we believe that that was the proper ruling by the trial court, and it fits well under this, under the statutory and the case law for what is allowed to be brought in during the punishment phase of a death penalty proceeding. So that is the standard there. The court didn't commit any error. And the state's position is if this court decided there was some error, that maybe there was some tenuous relevance to that information, that therefore, if we assume error or we find error, then it still was not harmful, because the trial court admitted the other part of that proceeding, of that deposition testimony. The defense still got to call, I believe it was 17 or 18 witnesses during the punishment proceeding, including numerous experts and scientific evidence of the defendant's brain structure, function, and things like that, and all kinds of other witnesses. So the defense still got to put on a robust, very robust punishment case. And we're talking about one part of one witness in that proceeding. And therefore, we believe that based on that and the state's very compelling evidence in guilt, innocence, and some of the other evidence the state put on during punishment, that there was no harm here. If there was error, which we don't concede and don't believe there was, but even if there was no harm that can be found here. This court can be comfortable and satisfied beyond a reasonable doubt that this had very marginal weight because it didn't have anything to do with the defendant when he was alive. And the evidence was so compelling that the state put on of the very brutal nature of this double homicide. And so that is our position on issue number 4. I do want to talk a little bit about issue number 2 and I want to talk a little bit about issue number 2. This one is a little bit harder to narrow down what the exact issue is. It was litigated at the trial court level, but on appeal, appellant makes 2 arguments, and that is, one, that the indictment should have been dismissed based on an alleged intrusion into the defendant's Sixth Amendment right to a fair jury trial, to a fair trial, because of intrusions into his attorney-client privilege. That is one argument that he makes. The second argument that he makes is that the district attorney's office in Hunt County should have been disqualified from, depending on how you read the argument and also what happened at trial, whether it's a limited recusal or disqualification for purposes only of hearing this motion to dismiss, or if it's the whole thing. Now, at the trial court level, it was very clear that the defense was only seeking to disqualify the office for this motion to dismiss. Now, the appellant on appeal raises a more global disqualification argument. That was not preserved for this court to review. It was an intentional decision by the defense.
Excuse me.
Very strange.
Yeah.
How far back do I need to go? I have sympathy. I run the soundboard for church. I know how that goes.
Why don't you turn it off?
Okay, I can project.
Thank you.
Taught me that in law school.
I can hear you fine.
Okay.
Okay.
All right.
Was there an actual hearing to disqualify the DA's office?
For the limited, yes, there was a hearing for the limited purpose of the motion to dismiss. There was a hearing, and then there was a subsequent hearing on the motion to dismiss. I'm sorry, Judge, I can't remember which one you asked. about a motion to dismiss. So there was both, and it was a contested issue, but there was a very intentional choice by the defense not to seek disqualification for the entire case. And it's obvious because that's what they filed. They filed a limited recusal motion or disqualification motion. Now, the appellant raises on appeal that it should have been total disqualification. That's not what was requested at the trial court level. Therefore, that was not reserved for this court to consider. That is our base argument there. And of course, we can talk about the motion to dismiss the indictment, and I think that should be issued. The trial court, obviously, the state's position is that if there is an intrusion at all in this case, and we do not concede that there was, that it did not rise anywhere close to the standard that's required to dismiss an indictment, never to be refiled, basically, with prejudice. That did not happen here. What happened here does not rise to the level that this court found in the Fry case, I think that was in 1995, or any other case, the Morrison case, which the Supreme Court was talking about. That's where we have these rules and these ideas about when dismissal is appropriate. That's not what happened here. The Fry case, if we're comparing it, involves a district attorney's office literally calling a defendant who didn't have an active indictment at the time and trying to talk to him when they knew, because he told them that he was represented by counsel or had an attorney, and they continued to speak with him about his side of the story and later filed an indictment.
So how do you classify what happened with the observation of the jail logs?
How do I classify it as?
Well, the defense classifies it as an illegal act and, of course, an intrusion on the attorney-client privilege.
Yes, absolutely. Well, I can classify by what it's on. It was not illegal because there's no statute that was violated. So it is not illegal in any sense. No federal or state statute violated.
Court didn't issue an order? The court didn't issue an order?
The court did issue an order, but I don't define that as being an illegal act. I think the court has the legal authority, of course. What I believe happened here was I struggle to come up with the words for it, but at most it was the jail, the Munch County Detention Center, either on accident violating a court order to not make that information available to anybody else.
Did you ask to see it, or did they just give it to you?
No, neither of those things. In Hunt County and in a lot of counties, we have a unified software system. Now, there's a side for the prosecutor's offices, there's a side for the district clerk, and there's a side for jail information. And in the jail, we have access to almost all of those realms. We have the access that's granted to us, including jail information. We can look up biographical information on a defendant, we can look up documents filed since he's been in jail, if there's been grievances filed, if there's been complaints filed, if there's been disciplinary action filed. And one of the things that is available to those who have access is contacts while they're in jail. And it just produces a list on the computer of the people that have visited a defendant. And that's where that information comes from. The state did not request that information, especially in this case. They did not surreptitiously provide it to us without us asking. It's just there. And so I think that at most what we have is a misunderstanding about when somebody asks for this, you cannot provide it. And the defense was upset that there was not some block put on it that made it so it was not viewable by anybody else. That would seem to be their complaint.
Was the order delivered to the jail? Did the jail have any, the people who would input that information into the database,
Yes.
were they given notice that there was an order from the trial court?
The record indicates that they were given that order, yes, Judge. They were given that order, and that, but that is an important consideration, but it is not ultimately decisive on the issue of whether or not the Sixth Amendment rights were intruded upon. Was it a mistake that was made by them? Yes, it was. Was it something that resulted in a Sixth Amendment violation, resulting in probable dismissal of the indictment? Clearly not, because the information that the
it could reveal, for example, a strategy. If you knew what kind of medical professionals, for example, had showed up to interview the defense's client, then you might discern from that they might be advancing towards a certain kind of defense because of the type of doctor that was coming to see him. So, I mean, there is that, right? You would acknowledge that.
Yes, Judge Erie, I would acknowledge that, and in the proper case, perhaps that would be something that would lead to some sort of sanction, be it limitations on cross-examination or some other sanction short of dismissal of the indictment. But in this particular case, the issues and talk between, and the record is clear on this, I believe as well, is that the questions of whether or not the defense was going to include some issues regarding his mental health or his stability in that regard, there was no question that that was going to be something that the defense was going to bring up. It had been talked about between the parties informally before that for months. And so...
And that's in the record.
There's record of us having conversations. Well, we talked about it during the hearing, yes.
I mean, I want to make sure that you're not giving us just your personal recollection
Yeah, that is
versus what we can see in the record, yeah.
The record does reflect that there were during the hearing, there is testimony from myself that there was conversations about there being mental health issues and conversations about their client. That is talked about in the record. And even, Judge Erie, your question is well taken about the potential strategy. The court in Morrison, the Supreme Court in Morrison does say that if the state learned the details of a defendant's trial strategy, that perhaps that would lead to some sort of sanction that might be appropriate. But that's not what happened here. Even if we take everything that happened, the Supreme Court said that one of the ways is to learn the details of the trial strategy, and that is not what happened here. What happened here is learning names, and then when those names were made, when it was made clear that those were mental health professionals. Again, there was no indication in the jail record that those were defense experts. But when it became clear that they were mental health professionals, no further work was done on. And those are not, even on the outside realm, cannot say that those are details of trial strategy. See that my time is up, and now timer's counting up. So thank you very much for your time. Unless there are any further questions.
Thank you, counsel.
Thank you.
My friend here stated that no harm was done by the surreptitious discovery of these individuals. And in fact, the only party that said that there was any discussion about mental health was Mr. Little. So, and that is in the record, sir. But he is the only one, to my knowledge.
Anyone say from the defense side, oh, that's not true, Your Honor? Anybody say that to contradict the claim that was being made on the record?
I believe they did. I believe what they did do was to say, we do not have anything specifically talked about. And let's face it, LeBron requires specificity. And that was not here. Mr. Lilly was asked, when you discovered the potential expert witnesses that may have been procured by the defense via an ex parte confidential seal order, did you notify anybody that the name of these next role is? No. Did you do anything about it later on to rectify it? No. Did you tell defense counsel, did you go about it? Well, I did when I filed the motion. In fact, his closing argument on that hearing is very, very revealing. He says, what happened here is the state wanted to file something, they knew they should probably get around to filing it, and to wait until they, the defense, had to disclose their experts in a case where everybody knew that there were experts all over the place. There's no secret about that. Really? for us to have to wait as the state until 30 or 40 days before trial, which should have put in Christmas, maybe right after Christmas, for us to only then file the Grown motion in the real world courtroom and capital litigation, that just doesn't make any sense, Your Honor.
Can you maybe give us your articulation of how this discovery by the prosecution harmed your case?
Certainly. The main thing I can think about is this. From everything that I've been able to tell about the case, Mr. Williams is a little bit paranoid, and he is untrusting. And if he cannot trust that the things that he believes are going to be kept confidential, why would he trust anyone? The court should note, and it's not here in the brief, of course, but after the hearing, Mr. Williams immediately made an accusation against one of his counsel. And I believe, in my mind, that had to do with some of the lack of faith in the confidentiality that was getting accomplished here. That's problematic. Counsel must be able to communicate straightforwardly, honestly, and confidentially with their clients. If not, there is no reason whatever for us to have it. Which was premature, as they have mentioned. So now we find out, by the filing of a motion, that there's a violation. We find out that, okay, now the court has said, well, no harm, no foul. If there's no harm, no foul, then why would I want to talk to anyone else? Why would I? And in fact, in the trial, Mr. Williams says, I want to testify because I really haven't had any ability to talk to my lawyers. And I don't think he meant that they don't come by and see me. I believe it had to do more with the fact that he just did not feel that what he was getting was entirely confidential. That confidentiality matters. It suppresses, the lack of it suppresses all of it.
But there was no disclosure of what any of these people said to either the lawyers or the defendant.
I think
just names.
That's true.
And eventually the names of the experts would have to be disclosed anyway.
They would. However, I'm saying that this had a chilling effect on the defendant. Okay. Defendants have a tendency, and I know all of you know this, they have a tendency to come back and they've got to say, look, whatever I tell you and whatever we discuss, and the people that I send to you, or that come to see me, at least until the proper time, needs to be kept in secret. As defense attorneys, we do this all the time. We ask for ex parte orders. There's a reason for that. We don't want the other side to know what our thought process may or may not be. And the violation of that is also a violation of the attorney work privilege. Okay? And that's where that piece goes. Now, if I may, because I've got so little time left, what I would like to mention here is when we come back to the deposition, they state that these things are not, that 78 or 79 pages was really immaterial. It seems to me that when a court says, well, I don't, here it is. The court stated, for instance, Ms. Smith describes in some detail the windows of her house being pushed in by an intruder who came to the house when her mother was not there, raped her, got her pregnant, and those kind of things, but you can't draw any conclusion about the defendant's upbringing from that experience. Are we serious? Did we all grow up in a vacuum? Are we not our grandparents' grandchildren? There are untold amounts of subliminal issues that occur. And therefore, as far as I'm concerned, I believe that it should have been heard, because that has something to do with the way the family develops overall.
Was there any evidence that any of that affected the development of this defendant's family?
We never got to it. I believe that when you're raised in kind of an atmosphere of that kind of violence, I think that's entirely possible.
But didn't most of this happen before he was even born?
I don't think that matters. And
Well,
the reason I say that, Your Honor, is this. None of us, again, were born in a vacuum.
But we
Yes.
wouldn't want to hear, somebody get up and testify in the middle of a trial about a particular defendant's actions about, for example, the dropping of the atomic bomb on Hiroshima. But it has an impact because after all, there are atomic bombs and people have used them. Not only that, it was the U.S. At a certain point, you're so, and I don't mean to prolong it, but it's so far removed from this defendant's actions and his own personal moral culpability that, well, go ahead, respond to that.
Well, Your Honor, I would agree that it is far removed, but I'm not sure removed enough, okay? A violent rape is a problem. For myself personally, I represented someone who, in a capital case, whose mother was violently raped in front of him at the age of 5. And he was mentally ill from that day on. So
But that's very different from what you're describing.
it is, except for the fact that you have these things and you have these attitudes that people grow up with. I don't think there's any excuse for what happens, but I think that we need to at least get a good grip on what that family was like. And as I see my time's up, is there anything?
Thank you, counsel.
Thank you.
The case is submitted. Let's give a minute, try and get this fixed.
So we just take a 5-minute break.
She said no.
I don't take no action.
Sharon.
Okay, the court will stand in recess for 5 minutes. Call now cause number PD 018624, the state of Texas versus Justin Heath Pedit.
Presiding Judge Keller, counsel, may it please the court.
You're very soft-spoken. Will you speak up, please?
I
Thank you.
certainly will.
Yes,
Thank
ma'am.
you.
Presiding Judge Keller,
Good.
counsel, may it please the court. My name is Amy Blaylock. I'm an attorney in Tyler, Texas, which is Smith County, Texas. And I'm here today representing Mr. Justin Pedit. I'm his attorney. Mr. Pedit is the petitioner here today. He was the appellee in the 12th and defendant in the trial court. This case today presents a very, I think, narrow issue, a legally discreet is what I'm calling it, issue of whether a passenger in an automobile has the standing to contest his seizure and to contest and try to suppress the fruits of that seizure, which is the evidence used to prosecute him. The 12th just found that this was a standing issue and said that he did not have standing, effectively, ending his appeal. This is a traffic stop case, and I know the court is aware of the facts. Mr. Pedit was a passenger in a vehicle driven by a lady named Bridget Tobler. They were out in Smith County, rural area in the eastern part of the county near the Gregg County line. This was on July 4th of 2019. It was 10:30 in the morning. It's a rural area, not a particularly crime area or anything, just a rural road. Mr. Pedit is a motorcycle mechanic, and he was riding with his friend, and they passed on this rural road a trooper, and they were not speeding at the time they passed, but the trooper found in his rear radar that they had begun to accelerate. This was an area, there was no speed limit signs, and their speed limit sign was about a mile away. And they were going about 45 when they passed, not speeding, and then they briefly accelerated, on the road. So the officer turned around and pursued them. There was no, they didn't flee. They pulled into a driveway, like a driveway. There was no shoulder on the road. They pulled into a driveway of what was maybe an abandoned house, or not a great house.
I thought the trooper had made a point of saying that they didn't pull off to the right, and it struck him as odd that they pulled off to the left when the law requires them to pull off to the right. But you're saying there's no shoulder on the road.
Right, that's right. And that was in the judge's findings of facts, that she did not find that a particularly compelling reason to give suspicion. They did pull over pretty quickly. And
Counsel, is this a case where we need to harmonize Lewis and Cothey, or get rid of Lewis in favor of Cothey? What is the rule for standing for a passenger in a vehicle that you are advocating for?
yes, Your Honor, we advocate that a passenger in the vehicle has standing to contest his illegal seizure.
When? I mean,
When the fruits of that seizure are used to prosecute him. That there's no need to find, the 12th court seemed to conflate search of the vehicle. And this is not what we advocated for. It's a seizure. Mm-hmm. That's the illegality, is his seizure on the side of the road when he was held, in this case, for approximately an hour. That's where he has that standing. And I know that both sides argued the Cothey case, if I'm saying that correctly. And Cothey was a little bit different because he was the driver of the car, and they searched his passenger, and this court found that he had standing because that was a seizure, and there were things found on the passenger in that vehicle, and they ultimately found that the detention, or there was not a prolonged detention, and this court held that the prosecution could go forward.
What makes the passenger seized in this case?
By being held on the side of the road. He was not free to leave.
Okay.
And that's where he has an expectation of privacy and not being seized that way that society is prepared to recognize as legitimate.
What's the alternative in a case like that where the driver is legitimately being held, the passenger's there, and they are in the middle of nowhere?
Well, they could wander off into the swamps of Smith County. I mean, he does not free to leave. He was, I don't know if he's even from this area. So he's held, and they've not written the citation. There's nowhere for him to go. There's no option for him but to be seized, and they're asking him questions. this entire time. They're saying, oh, do you got any warrants, and do you have drug use, what's your criminal history? They are actively engaging with him. It's not where,
Yeah, this is not a situation though we're not here to decide whether or not, it may very well be possible, and the state may have very good arguments as why this detention could have been prolonged. We're not here to determine why it should have been prolonged or if it should have been prolonged, if that's okay. We're just here to determine whether or not the passenger had the standing to contest the search.
that is correct, Your Honor. The 12th never reached that issue.
Okay.
And that's what we would ask this court to send it back for that consideration once it's established that Mr. Pedit did have standing, because they did not reach that issue. So that's very, very clear. So that's why I think it's a narrow issue.
How does your argument square with the Supreme Court's opinion in Rakes?
Well, I think that Rakes helps us, Your Honor, because one of the things that Rakes said was that, that I really like about Rakes, and maybe I'm reading it wrong, but that the courts have to be aware that we don't get too caught up in like what they called arcane distinctions of tort law and property law to rule on Fourth Amendment issues. And that's what I like to take away from Rakes, is that this is a constitutional query, a Fourth Amendment query, and to look at it from that perspective, and to look at it from that perspective of whether he is being seized and whether his Fourth Amendment right has been violated.
Well, I mean, I know you're arguing that he's detained, and I take it, and what I'm seeing is that your argument is he's detained because the driver of the car is detained and the car is detained, and so therefore he's detained. That's sort of, is that it? Or is
No.
there, I mean, the officer asked him some questions, but the officer did not search his pocket for the tools. So I'm trying to figure out what else should lead us to the conclusion that he was detained.
Well, Your Honor, he was not free to leave. There had been no, they had him, they were asking him engaging in questions, and with the passenger, with the driver. Like, these stories are not, they're not matching, or I find them, unreasonable. She doesn't really know him. He doesn't know her. There was active engagement, and he was not free to leave.
Did they do a pat down of the appellant?
No, he did not let them search he had some tools in his pockets, and so they asked for consent. They asked Ms. Tobler for consent to search the car, and she refused as well. So there's no searching, and the trooper even said to his partner, which is on the video, that he didn't think he had reasonable suspicion to keep them.
But was there any exploitation? Let's assume for the sake of argument then that your client was detained. Then was the discovery of the items that were found in the vehicle a result of the exploitation of that detention?
Yes, it was, because there would have been no search unless they were held there. The officer had to hold them there for that hour. It took the drug dog to get there. So that's how they found the evidence, and it's the firearm that's the subject of this prosecution.
Well, let's assume then, for the sake of argument, that there's really not sufficient reasonable suspicion to continue the detention of the passenger. If we find that there was sufficient reasonable suspicion to continue the detention of the driver and the vehicle, is that enough? Is your client out of luck?
No, Your Honor, I don't believe so, because he was being held. I don't think we're there, though, at this. I think he was being held, and that's a great query, but I don't think in this situation he was being held. And because they were...
I mean, what was the officer supposed to do? Offer him a ride?
Well, you had to let them go. He didn't have reasonable suspicion for either one of them.
But my point is, if he had reasonable suspicion with regard to the driver or to the vehicle, then would that be enough to justify the continued detention of your client?
Your Honor, I honestly don't think so, because I think that it becomes...
But then what was the officer supposed to do vis-a-vis your client when he had legal justification?
He could have said, "You're free to go. Can you call a friend to come get you? I'm going to hold her." He could have. There could have been an affirmative, release of him. Yeah, could you have a friend? Because I'm going to hold her. I don't like this car. She's tags out or whatever. Can you call and somebody come get you, or you want to walk away, or what? You could have let him go. He did not.
Into the swamps of Smith County.
I'm actually putting the Fifth Circuit on a case we had in Beaumont, but yeah, into the dry lands or wetlands of eastern Smith County. Not a lot out there in that area.
So is there any opinion that you think, are we gonna have to overrule anything if we found in favor of your client?
No,
Or nobody has spoken on this particular question
Right.
before?
I think the federal cases have spoken on a little bit more aggressively, but this court with, I don't think you have to overrule anyone but the 12th. I think this court's precedent, Cothey, it's not outlandish to say a passenger has standing to contest an illegal detention, a prolonged detention, and contest the fruits of that
But
search.
the Court of Appeals relied on Lewis, though.
Yes.
So you don't think Lewis is at risk if we agree with your argument?
I don't think so, Your Honor. I don't think you have to overrule it, but I think in this case, I think it's just, looking at the facts of this case, it does not require that. And I would, always proceed with caution when I ask you to overrule something, but I think this is more in line with this court's opinion in Cothey, if I'm saying that correctly. Yes, that would be in line with that, and I think you're just asking to overrule the 12th. So my yellow light's on if there's no further questions.
Thank you, counsel.
Good morning. My name is Michael West. I represent the state of Texas in this case. First, I'd like to throw a little kink in this proceedings as far as the standing question, because I was sitting here last night in my hotel room, and it was late at night. I'm trying to think of what can I say, what the words to come to me, and suddenly a shaft of light came down from the ceiling, and the chorus of angels was singing, and lo and behold, the light landed on King versus State. And that's a case out of this court just from last year, where the question was standing. The facts of that case were somewhat different. I didn't run across it because I was so focused on passengers. But in King versus State, which is 670 Southwest 3rd, 653, incidentally, that case came down 2 days before the suppression hearing in this case. And in King, there was a truck driver who had been arrested, and the evidence showed that at various times when he's on the road, he's actually living in his truck. And of course, unquestionable standing in those situations is just set home away from home. But what happened was, when he was arrested, they searched his vehicle and they inadvertently left his cell phone in the vehicle. And a couple days later, 3 or 4 days later, the officers asked to have the phone returned to them, and that was the point in which the seizure occurred of the cell phone, and they got a warrant and whatnot. The question was whether he had standing at that time when the cell phone was seized to attack the search. And this court, 8 members of this court, decided that the standing takes place at the time of the seizure. But more importantly, I noticed in this case was that the court said at the hearing on the suppression motion that you have to present some evidence that you have this standing. It's an individual right, belongs to you in the Fourth Amendment, but if you want to assert that right, you have to establish standing, and you can't just rely on your motion to suppress. You have to present evidence showing you have a reasonable expectation of privacy. And in this particular case, in Mr. Pedit's attorney did not present a single witness. His cross-examinations were primarily concerned with questioning the recollection of the officer, but no testimony was offered to establish that he had a reasonable expectation of privacy as a passenger in that vehicle. And in fact, during cross-examination of the trooper, his attorney went to special pains to try to ask the trooper, what is it that ties my defendant to that backpack where the shotgun was found? And just based on the standing question as it was presented in King, there's no evidence. He hasn't met his burden initially to even...
If I'm remembering King correctly, though, the truck had been returned to the owner of the truck by the time they realized that they had left the phone behind. I mean, that's a different situation entirely.
It's a different situation, but it's still the same right. It's still the same expectation of privacy that you have to establish your burden. And the facts are going to change, But you have to come into court, if you want to complain about a search, come into court with some facts to show the court, this is why I had a reasonable expectation of privacy.
Well, why isn't that we would wouldn't just analogize the passenger to the cell phone at the time that the car was seized? I mean, essentially the car was seized if the defendant or the passenger or the appellant is sort of like an article in the car. Isn't he seized as part of the car, the stop of the car?
And that's why he has a right to challenge the stop. Under the law, a passenger does have a right to challenge the stop of the vehicle. And in this particular case, he's complaining about a continued detention. But if you look at the record and watch the video, these officers were going about it in a very professional manner. In fact, within 11 minutes of stopping the vehicle, they decided to call the drug dog. And during that time, what they were doing during that 11 minutes was everything the law allowed. Obtain ID, run criminal histories, ask questions about criminal history. And then after they got that information, and under the facts of this case, both of the people involved, both the driver and the passenger, had drug histories. They had.
But that's getting beyond the standing question, isn't it? So if he has standing to contest the stop, the initial stop, why doesn't he also have standing to contest the continued detention of the car and him there at the scene?
Well, because the courts have said that the standing question to attack the stop is based on his individual right to freedom of movement and things of that nature. So when you stop the vehicle, you interfere with that right. So you have the right as a passenger to argue that, hey, you interfered with my personal right to remain free and undetained. But once you get to that point where you've got to point to and standing to attack a search, you've got to establish a reasonable expectation of privacy. So you've got that.
Lengthy detention has nothing to do with his right to standing?
His freedom
Well,
of movement? Yeah.
That's my fallback position would be that under the record of this case, there's plenty of evidence to establish that there was a reasonable suspicion to detain him. But as far as standing goes, according to Lewis, according to, and I'd like to say according to King versus State, since he didn't meet his burden, but according to Lewis, you've got to have an exploitation of an illegal search or detention to be able to establish standing to attack whatever evidence was seized. And in this
So what
case,
do you make of the officer's comments on the video that they didn't have reasonable suspicion?
well, it's funny because but he also testified, once I ran that criminal history and I found out that he had lied to us because he asked the defendant specifically, have you ever been arrested? And the defendant was on probation for unlawful use of a motor vehicle. And he said he'd been arrested for DWI, and the trooper specifically asked him anything else, and he said no. And then he gets into his vehicle to run criminal history, and it turns out he's got 2 drug arrests within the last 2 years before the stop that he didn't tell him about. And the trooper testified, that was the final straw for me. This traffic stop is over now. Now we're talking about calling a drug dog. I've got reasonable suspicion. And he also involved in these facts are the defendant not testified, but told the officer when asked that he had a girlfriend, someone very close to him, who used hard drugs, and that he used marijuana.
But we're still talking about standing, so I want to ask you, how do you reconcile Lewis with Brendlin? The Lewis case with the Brendlin case out of the U.S. Supreme Court?
Well, Lewis, the standing in Lewis was all predicated on the exploitation of the stop, which was found to be illegal detention. But the court also said you have to show that somehow had an impact on the search to establish your standing. And in Lewis, they said that he could have walked away. The defendant could have walked away, and it wouldn't have made a difference, because the officer had the right to search at the time. And it's the same thing in this case, because before they called for the drug dog, that defendant could have walked away, because once they decided to call for the drug dog, that was the case. And the defendant, you can see him on video smoking a cigarette, sitting on the ground, casually flicking a syringe into the woods. He just, at that point, the search was basically, this is the case. You have, I'm trying to verbalize this.
Well, let me ask it this way. So
Okay.
Brenlin, if I understand it correctly, said that a passenger has standing to contest a seizure of a car. The passenger can say, oh, this stop, I have standing to contest the validity of this stop. So why wouldn't he also have standing to contest the prolonged detention of the car he was riding in?
Well, basically, because the law says it. The Supreme Court has said you have standing to challenge a stop because it's an interference with your right to liberty and your freedom of movement. But once you get to a point where you're talking about a search of a place or a thing, you have to show you had a reasonable expectation of privacy in that place. And there's no evidence of that in this case. It's just the opposite. If you look at, let me find that case.
So I guess you would limit Brenlin to the stop itself, the initial stop, and it has no bearing on the prolonged detention. Is that your position?
Well, for one reason, they didn't challenge the stop in this case. The only thing they challenged was the prolonged detention. The stop in this case was based on 3 traffic violations, and so.
Right. But Brenlin would give you standing for a stop, and you're saying it would not apply to the prolonged detention. Is that what you're saying?
Basically, yes.
Okay.
But you're also saying that he wasn't detained.
I'm sorry?
You're also saying that the defendant was not detained, right?
Well.
He wasn't told he could leave, but he wasn't told he could go.
Before they made the decision to call for the drug dogs, they were in basically a Terry stop situation. And the officers were performing their jobs, their duties, the way the law allows them to. And he wasn't detained until at that point where the officers decided to call for the drug dog. Then they said, the process of writing traffic citations is over now. We're now into the phase of investigation where we think we have reasonable suspicion that there may be something illegal in this vehicle. But up until that point, he was just temporarily detained. I would guess it's how it's described as a Terry stop.
Is there any distinction between standing as a principle of law and the reasonable expectation of privacy? I mean, are those essentially, are they necessary components of the same thing, or are they things that you can separate? Because I think I hear you suggesting that maybe we should treat them as separate things.
Reasonable expectation of privacy is the test for standing. And if you have a reasonable expectation of privacy and it's one side society is willing to accept as reasonable, then once you establish that, you do have standing to contest a search. That's been the law since Rackus, even. And it's, in this case, there's no evidence, number one, that he had any reasonable expectation of privacy. And secondly, he never claimed to have an interest in the vehicle. It wasn't his vehicle. The driver didn't even know his full name. And he didn't have any dominion or control over the place.
So my next question is, why does a driver of a vehicle who's stopped on traffic, why does that person have a right not to be detained any longer than is necessary for the officer to dispose of his ordinary duties?
Well, I think it's because there's a legitimate interest in the government being able to enforce the law, protect society, and you cannot get a search warrant before you stop a vehicle.
No,
you have to react to the facts.
My question is about what is the source of this right to not have a detention go on for some period of time beyond what's necessary to issue a traffic citation, for example? What is the source of
I
that?
think it's a permutation sort of your Fourth Amendment right to be free from illegal searches and seizures.
It's the seizure right?
Yes, sir.
So it's about seizure, and I'm wondering if, does this case turn at all on the distinction between a right against seizure versus a right against search?
I don't think so, because the differences between the two are well established under the law. Your right to not be, the right against being seized or stopped, I guess, is, as a passenger, if you're talking about a passenger. As a driver, I guess it's the same interest. Essentially, it's your right to be free from intrusion from the government, interfering with your life, and pulling you over to stop you for some reason. Now, the right to be free from detention, I guess that comes along after they've already established the reasonable suspicion. I'm not sure I understand your question, to be honest with you.
Yeah, well,
Counsel, do we know who actually owned the backpack and the shotgun? Was there anything that,
I'm sorry, I don't.
do we know who owned the shotgun?
We don't know who owned the shotgun, and the shotgun was found in a backpack in the car in the back seat, and the only tie to the shotgun that is available under the facts of this case is that there were syringes found in the backpack and in the car that were similar to the syringe the defendant flicked off into the woods that the officers recovered later, and he never asserted an interest in the backpack. So that would be the evidence that ties him to it initially. And of course, that's a question for a jury or a judge once it gets to trial, whether there's sufficient connection between the two. But as far as standing, he didn't declare any interest in the backpack at all.
So the syringes were similar, the ones in the backpack, to the ones that he had in the woods?
Yes, sir.
Okay. So if it's his backpack, wouldn't you assume he has a reasonable expectation of privacy in the sawed-off shotgun that's in the backpack?
Well, you'd have to assume that because they didn't put on any evidence that he did have a reasonable expectation of privacy anywhere in the vehicle or in the vehicle itself. So it would just depend on the facts of the case.
I thought I heard you say a little while ago that, or maybe it was Ms. Blaylock, that suggested that his counsel tried to establish that he didn't have, that he wasn't connected
That
to
was
the
me,
the
yes.
backpack, yeah.
In cross-examination, it's page 67, 69 in a motion for suppression hearing. He asked the officer several times, what is it that ties the defendant to this backpack? And to me, that establishes that he's lacking, his attorney is trying to establish a lack of reasonable expectation of privacy in that backpack, because if there's no tie to it, then what expectation would society feel was reasonable in a backpack you claim no ownership of, in a vehicle you do not own? And to me, that, yes, he did, the defense attorney did do that, but to me it shows a lack of expectation of privacy in the backpack. And that's all I have, unless there's any other questions.
Okay, thank you,
For
counsel.
these reasons and the reasons cited in my brief, I'd ask the court to affirm the 12th court's opinion, and thank you.
Thank you, counsel.
To me, it's always a bit of a conundrum when the state wants to argue it's either standing or sufficiency of the evidence in this case. Do you have enough interest to challenge it, or do you have enough ties to prove your sufficiency? But that's I guess, a decision or discussion for another day. My friend Mr. West brought up the issue of King versus state, and that in King, there was a finding that there was no standing because of the lack of possessory interest in the items. But I think I'd like to respond back to that, that this is another case where it's items to be searched, possessory interest in items. And this car had been returned, and the items were what was the subject of the lack of standing. And that he did, and I've mentioned that we don't want to get too caught up in, this is not a case where we're talking about items, we're talking about the seizure. And that's what gives Mr. Pedit the standing in this case. And I know that King was also, Mr. West talked about the burden of proof wasn't met because you have to have testimony that there is an interest in, where's your privacy interest? And our response to that is that the state established that when the trooper testified that Mr. Pedit was held by the side of the road for an hour, approximately an hour.
So counsel,
That's the
here's
detention.
my question. It seems like your biggest complaint is not the detention of your client, but the detention of the driver, right? Like,
No.
well, but if you let's just say, the minute the car gets stopped and the trooper gets out and says, let's say the trooper said to your client, you're free to go, and then does everything else the way it went down, they still find the backpack and then the shotgun. I mean, I guess that's my question is where, I mean, you're talking about sufficiency, and that's obviously an issue for another day, but they're still gonna find the items in the car. So, I mean, isn't the bigger problem for you not necessarily the detention of your client, but the detention of the car and the driver?
They're both a problem, but he's detained, and that's his right. He was held on the side of the
No,
road.
I understand that, but the discovery of the evidence of the backpack and the shotgun aren't necessarily related to the detention of your client, right?
I would disagree with that, Your Honor, respectfully, that he was held, and because he was held, and because there was questioning going on with both of these individuals, and their answers, were found to be somewhat, that he didn't know her, she didn't know him, he didn't know her, they were dependent on each other, they were interdependent, that detention was critical, his detention was critical. They had to wait there while he called the drug dog, and it was his answers that the officer felt like that he wasn't being truthful. That's why they held him there, that he wasn't completely forthcoming on his prior criminal history, although he did tell them some of it, but he didn't, he has had other arrests or, other problems with the law.
Did your client testify at the hearing?
No, the testimony was by the...
I'm curious, it seems like from most of the cases I've read around this area, there's a suggestion that it's the defendant's burden. Am I misreading that? To demonstrate standing?
It is the defendant's burden, and we believe that it was met in this case by the officer's testimony that he was held.
But did he say he was held? Did he use that word, I was holding him? Or did he say I detained him? Or did he say anything that directly would allow a reasonable inference that he was detained based upon some description he gave?
Well, he testified that they were held there and the length of the detention, and that he was questioning both of them during the time that they were held.
I remember the part about the questioning. I'm trying to figure out if you know where, what record-based testimony suggests that he said they were held, right?
Yes, I mean, there was a video introduced,
Right. Yes, but
and
that's not somebody saying I held him. That's a video showing that the car gets pulled over, right?
But wasn't there testimony about the length of time it took to get the dog and,
yes,
But even that goes to, it seems to me, the length of the detention, but not necessarily to whether the defendant could not leave, right? Because that's the ultimate question in deciding whether he was detained, was whether he was free to leave.
that's
And
right.
I mean, the fact that he didn't exert that opportunity alone, I don't know if that's sufficient to show that he couldn't, right?
Well, that's right. I don't think it was a reasonable. I think if he had gotten up and walked off, officer might have had something to say about that.
Well, if he did, then we would know, right?
Right.
Then we would know that he was
Right,
detained
but
and he wasn't free to leave.
I think a reasonable person would have felt like they would have been detained. And Your Honor, I think it's important to remember that standing was not raised at the trial court. I think everybody assumed that Mr. Pedit had standing. This was an issue that was raised at the 12th. So I think everybody was
But
assuming.
again, it's the defendant's burden, right?
That's right, and we
So-
believe that we met that. When it's the burden, it is the burden, of course, to say that the search is unreasonable, and they meet that when they say there's not a warrant. And so that's why this burden immediately switches to the state, to say that there was not a warrant, but this is why we had reasonable suspicion to detain them. But I think the standing question is evidence, and I would say, you know, it's because it was not raised by either party, but there was evidence that he had standing and he had an interest because he was held there. And we may disagree on.
That's really what I'm asking.
Yes.
I'm trying to, let's boil it down. What are the things that we can look at in this record to decide that he was held? Well, number one, the car he was driving in was stopped, right?
Yes.
Number two, the officer wasn't going to let that car leave for some period of time because he wanted a drug dog to come.
Right.
Number three, the officer asked him some questions. Well, officers are, generally speaking, take it outside the context of the situation, officers are allowed to ask questions of people just like anybody else can, right? So that doesn't necessarily lead to the conclusion that he was detained because he asked the questions. He didn't ever try to walk away. He certainly didn't get on the stand and testify, I felt like I was detained. Do you see what I'm saying? This is what I think you're asking us to drill down on. What are those factors that we can look at in this record that will persuade us that he could not have walked away?
Was that ever an issue? Did the state contest that he was detained?
No, it was just they had reason to detain him. And, Your Honor, I would ask this court to respectfully remember that they ran warrants on him. And they went back and they said, well, we know he doesn't have state warrants, but let's look for local warrants. Let's look for unpaid traffic tickets.
And
they were looking at him.
That was all before they started waiting for the drug dog, though, right?
Yes, it was a dynamic sort of situation. And they called the drug dog, I think, they called for it 11 minutes in the search. They didn't give a response till 7 minutes later, and then it took 40 minutes for the drug dog to get there.
Didn't we say in Lewis, and maybe I'm wrong, didn't we say that the relevant question as to whether Mr. Lewis, in that case, had standing was whether the search of the vehicle was comment by exploitation of the appellant's continued detention and removal from the vehicle?
Yes. And I think that this jurisprudence of this court and others are clear that he had a reasonable expectation of privacy and not being detained. Society recognizes that as legitimate and that is reasonable. And the Fourth Amendment is as beautiful today as it was written when it was first written, and it protects citizens. It protects Mr. Pedit. And it's an important case for him and all citizens of Texas.
So the state did not claim in the trial court that he was not detained? They didn't argue that?
No, it was
Okay.
reasonableness.
Thank you.
That can, just respectfully pray that this court will reverse the holding of the 12th and send it back for proceedings consistent with this court's opinion.
Thank you, counsel. The case is submitted.
All rise. Oh yay, oh yay, oh yay.